The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle, period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor.
Yep, get that out early. Absolutely.
He was the lead investigator on this case. And he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted, and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. More shockingly, you'll learn that lead investigator for the Massachusetts Police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things. Even though fellow officers of his, of Michael Proctor's, actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. But make no mistake about it, the evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it,
love it,
has his fingerprints on it.
Love it.
You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case.
They sure did. They sure did.
The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired?
It's pretty hard.
Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him.
Yep.
And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Loposada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating, and that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer.
Nice.
And his body had to have been moved out into the cold.
Okay.
You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise.
You tell him. You tell him.
Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. You'll take one look at these injuries and you'll agree with Dr. Loposada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night.
Yeah.
You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone.
Yep.
The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement, Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. Mm-hmm. But you know who else you'll find never saw a body on that lawn? The snowplow driver.
Yep.
A completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found, and we'll introduce you to, Brian Loughran.
He's the
He plowed
best.
Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. You'll also learn after this incident, and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn, Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold."
A question that still haunts
Hoslong
me.
to die in
Hoslong
cold.
indeed.
Now, she misspelled the first word. Hoss is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. Your job will be to make sure that the evidence isn't presented to you too cute by half.
Nice. You tell him.
The evidence will show that the evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one.
You tell him.
Not one civilian reported having heard Karen Reed say, "I hit him." The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert.
Yeah.
Brian Albert's brother. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants, he transported the evidence, he secured it, he submitted it, he did it all. That's Michael Proctor, and he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that?
Why
The
indeed?
evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. You'll find that there were 2 searches. The first and second search found 0, nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with 0. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision.
All right, so let's give a summary of that. That was pretty damn good too. For faulting it, I didn't find the story element to be as well connected from beginning to end as I did for the prosecutor's opening. I liked the way he started it with that sort of same strong emotional put, and also starting it with we're going to try to prove three things, or basically there are three things you need to know. The car never hit him, the car never hit him, the car never hit him, right? As opposed to what they did last time when they did opening, where they started out with Karen Reed was framed. It's like, yeah, I think they unintentionally gave themselves the burden of proof, or at least part of it. So I think they were much wiser this time in how they framed it. Like, we're just going to show you the reasonable doubt. And they still put elements of like the framing, the Karen Reed was framing, they still sprinkled it in, but it was much more subtly presented as opposed to last time being their entire thematic element, which I think was a mistake. And I think they corrected the mistake. But they still like provide the pieces, but it's all tied into the thematic element is now they can't prove it beyond a reasonable doubt. The car never hit him. That's the thematic element. That makes a lot more sense as a thematic element. And so then talking about the corruption, the problems, the Alberts and how they get intervened and all the stuff, right? It all feeds into that as opposed to it being a conspiracy, right? So it's a softer claim and therefore an easier to establish claim, and therefore doesn't require the jury to buy as much, and also doesn't shift the burden of proof. So I like that. I like those elements of it. I like the way it started. I thought his sort of cold opening was very, very good. And then sort of he transitions from that sort of cold opening after like maybe 5 minutes or something, 3 to 5 minutes, he transitions, and then he sort of gets into the bulk of it. For my taste, I found the bulk of it to be less well organized in sort of the story arc. The prosecutor's story arc, to my mind, was a better arc. It was more coherently told. It laid out a story from beginning to end, and it interlaced things in a better cohesive story arc. I felt like I didn't quite have that as well. I felt like there wasn't a cohesive overarching thing that was bringing the whole thing together. It felt like more like bits and pieces that wasn't really unified as much as I would have liked. The integration of the facts, however, into the story was very good. Referring to specific things, I think the prosecution did the integration better, but I felt that their use of it was pretty good. However, picking up on top of that, as opposed to the prosecutor's speech, Jackson's presence is just better. His vocal variety is better, and his public speaking is better. He's a better presenter than Brennan. Brennan was good, but Jackson is better. And Jackson had much more effective use of pausing, especially when he was saying critical names. That was really good. Like, that name is Brian Albert. That kind of thing, right? Very good use of pausing to emphasize points. When he needs something to be understood, like the car never hit him, he made sure to say it more than once. Good job. Other things like he said more than once. Good job. Referring to their own experts, always great when you can use the other side's experts or other side's witnesses for your case, right? It's not what I say, of course, it's what they say. That's always a good strategy. If you can quote the judge or you can quote the other side, it's always better than quoting your own side, right? So it's like, yeah, it's not me who's saying it, it's their medical expert. It's not me who's saying it, it's their police report. Also bringing up Michael Proctor and disgracing him, referring to him being fired multiple times, referring to him and how he bungled up this particular investigation. Very nice. Also appreciated. The opening didn't overstay its welcome. The delivery was good. What should we say in terms of a score? 9.6. I'll say 9.6. Maybe I'm a harsh judge, but I think the speeches were relatively equal. Maybe 9.7. I'll give him 9.7 because his presence and stage presence is just much more effective than Brennan's. I think Brennan laid out a more cohesive story, and I think story ultimately wins. That's why I'm giving him the slight edge. I think story ultimately wins, and I think he told a more cohesive story and he more integrated the facts into the story. Jackson's story, a little less integrated, a little less coherent, but he makes up for it through just sheer presence. Vocal variety, nice effective use of pausing, nice little bit of evidence there, bringing that in early to show that this is not obviously not a car wound, you idiot. This is obviously something other than that. Nice use of the DNA, nice use of the fact that they couldn't even get their own medical expert to agree that this is a homicide. That's nice, and so forth and so on. So I'll say 9.7. I liked what they did the first time, but this was better too. This was better too. So they're both at the top of their game, and I think a reasonable critic could easily disagree with my scores because we're fighting on the margins. So they're both 9+. And if you think Jackson was better than Brennan, I totally understand it. Right? I think for me, again, I think story is the thing. Story is the thing, and because people love stories, and the way that Brennan ended his with that, confession, words from the defendant's own mouth, juries eat that shit up. You know it, and I know it. Words from the defendant's own mouth, juries eat that shit up all day long. They will overlook all kinds of evidence if they think that the defendant confessed. You know it, and I know it. So let's not fool ourselves, okay? All the physics in all the world is mumbo jumbo. What juries love, they love words that come from the defendant's own mouth, because I'd never confess. I never say this. Because that's the way juries think, because juries are dumb. But that's how they do, right? That's how they roll. So Jackson has physics on his side, but Brennan has this nice thing at the end of the opening where he has this confession taken out of context or otherwise. Jackson has to explain it. If you're explaining, you're losing. This is a well-known idea. If you're explaining, you're losing. It's not great. He did it effectively. He explained it away. He didn't dwell on it, all the rest of it. But and Jackson, is the paid mouthpiece and all the rest of it, trying to get the woman off. So, how a jury will interpret it, who knows? But, 9.7 from Jackson, 2 outstanding openings. We have a great match. We have a great match fighting, man. We have a great match.